Welcome to Chapter 10, Introduction to Contracts. Contracts make business matters more predictable and are integral to the day-to-day business and personal life. Understanding how contracts are formed, the rules of contract law, and remedies the law has created to address harm that can result when formal contract rules don't apply enables greater control over one's life. Lord Melbourne, a former British Prime Minister, said, "The whole duty of government is to prevent crime and to preserve contracts." Judicial restraint makes the law less flexible but more predictable. Judicial activism makes the law more flexible but less predictable. People make promises every day. The law will enforce some but not others. Why is this? What distinguishes a promise the law will enforce, like a contract, from a promise the law will not enforce? One way to begin to understand the differences between unenforceable promises and contracts is to pose common examples of the former and ask why the law would not enforce them. For example, suppose one student asks another student out on a date, say to attend a party this coming Saturday night. The invited student makes preparations for the date, buys clothes, gets a haircut, whatever fits the situation. The student who issued the invitation doesn't show up at the appointed time. Can the student who was stood up sue the other for breach of contract? Experience would tell you that the answer is of course not. But why is that so? This promise involves offer and acceptance. Would you like to go to this party with me on Saturday night? I'll meet you at your apartment at 10:30. Sure, that would be great. Consideration. Each party promises to do something he or she is not otherwise obligated to do, and each gives his or her promise in exchange for the other's promise. Contractual capacity makes the parties over the age of 18 to dispense with this issue, and a legal purpose. Why can't the disappointed student file a breach of contract lawsuit as soon as the courts open on Monday? Certainly one reason the law would not enforce this promise is that while there is an offer and acceptance, there is no intent to form a contract. These parties thought they were agreeing to go on a date, which does not create contractual expectations, whatever emotional expectations it may raise. However, if one changes the facts somewhat, a businesswoman is at an out-of-town conference and arranges for a male escort from a legitimate companionship service to attend a business social engagement, then fails to show up at the appointed time, the parties' expectations take on the aspect of contract. One purpose of contract law, then, is to distinguish unenforceable day-to-day promises from legally enforceable promises. Agreement means that one party must make a valid offer and the other party must accept it. Consideration means that there has to be bargaining that leads to an exchange between the parties. The contract must be for the lawful purpose for legality to exist. Capacity means that the parties must be adults of sound mind. Contracts are promises that the law will enforce. Common law once required that all contracts be in writing, with the seal affixed. Later, some payment was required before a contract could be enforced. By the 1990s, courts began to consider the fairness of contracts before enforcing them. There are many different types of contracts: bilateral versus unilateral, express versus implied, executory versus executed, valid versus unenforceable versus voidable versus void. With bilateral contracts, both parties make a promise to do something to or for each other. With unilateral contracts, one party makes a promise to the other that the other party can accept only by doing something specific. With express contracts, the two parties to the contract explicitly state all of the important terms of their agreement. With an implied contract, the words and conduct of the parties indicate that the parties intended to make an agreement. Implied contracts can be difficult to understand, perhaps because the other paired terms introduced in this section present two faces of some aspect of contract, bilateral and unilateral, executory and executed. People do not enter negotiations with intent to form an implied contract. Implied contract is not another method of forming a contract, but a remedy a court may apply after the fact if there was no valid contract between the parties, but their words and conduct manifest implied intent that certain promises would be legally enforceable. An executory contract is when one or more parties has not fulfilled its obligations under the contract. An executed contract is when all parties to the contract have fulfilled their obligations under the contract. A valid contract is an agreement that satisfies the law's requirements. An unenforceable agreement is when the parties intend to form a valid bargain, but some rule of law prevents enforcement. A voidable agreement is when the law permits one party to terminate the agreement. A void agreement is one that neither party can enforce, usually because the purpose is illegal or one of the parties had no legal authority.